May I state the appearances?
Yes, yes.
For the prosecution, Mr. Sonye Habat, Kevin Kimani,
Present.
Wanjiro Waweru, and J.V. Mwite.
Morning, Your Honor.
Your Honor, for the suspect, for the record, for Mwite, Senior Counsel Kalonzo Musyoka, whose brief I hold, as the Honor will recollect, he was here. The Honorable Mother Karua, Senior Counsel, Dr. John Hamino, Mr. Gad Awoda, Mr. Nelson Osiemo,
Present, Your Honor.
Owiso,
Present.
Dr. Ekuru Aukot, the Honorable Eugene Wamalwa, Mr. Wajakoya, Henry Karauka, Memes Bashir, who is present. Your Honor, for the defense, I can confirm that each of the individuals whose names are given for the defense, each of them is an advocate of the High Court holding a practicing certificate. And it is in that capacity that we appear. Your Honor, the defense has an application to make before the plea is taken. That application, Your Honor, is that we apply for the taking of the plea to be postponed to give us an opportunity to challenge in the High Court the bringing of these charges, for the reason that even as the accused or the suspect was being arrested, there were valid court orders issued by the High Court of Kenya directing the suspect not to be arrested. So, Your Honor, we wish to raise the issue of contempt of court. Before the court that gave those orders. It is unacceptable for anyone, and in particular for the police, to ignore and act in violation of court orders. Confidence in the administration of justice is anchored on respect and obedience of court orders. So we have solid basis for challenging the bringing of these charges. And Your Honor, it is our submission that this honorable court, in order to promote respect for the administration of justice, will indeed accord an opportunity where the issue of contempt of court orders is raised for the accused, for the proposed accused, to make that challenge before the High Court. Your Honor, let me clarify. There were two sets of orders issued by the High Court. First, there were orders issued that the accused should not be arrested. And the arresting of the accused was contempt violation of those court orders. If you can hand over. Separately, Your Honor, that is a copy of the court order. Separately, Your Honor, there were orders issued by the High Court for the return of the guns confiscated from Jimmy Wanjigi, all of which were licensed. He had a valid certificate to hold the guns. And the orders of the High Court were for the return of those guns, which were returned, but also
They were returned?
They were returned to Jimmy Wanjigi in accordance with the court orders. But the further court order was for a reinstatement of the certificate to hold those firearms. All those copies of the court orders are there, Your Honor. So the guns were returned. The further court orders were for reinstatement of the firearms certificates. Firearms as specified, set out in the order of the court. So, Your Honor, perhaps in an attempt to get around the court orders not to arrest Jimmy Wanjigi, we learned that despite the clear provisions of Article 47 of the Constitution fair administrative action. Despite the court order that said return the firearm certificate to Jimmy Wanjigi, the police decided, without any notice of any kind to Jimmy Wanjigi, to cancel the firearm certificate in order to charge him with being in possession of guns without a certificate. Your Honor, as this honorable court is aware, before any adverse action is taken against anyone, the police were under an obligation under Article 47 of the Constitution to give a notice to the holder of that firearm certificate. That is what Article 47 is all about. That is what fair administrative action is all about. In order for him to be heard in his own defense before an adverse decision is taken. So we have these cogent basis and reasons for challenging